Hello and welcome to the Beach House 34 podcast. I'm your host, Christine Worth. If you're new here, welcome. And to our returning listeners, thank you for your loyalty. It's wonderful to have such a supportive audience, and I sincerely value your dedication to these episodes. Before we get started, this is a continuing series on the Darlie Routier trial readings. And if you're not familiar with the Darlie Routier case, she is a mother who, in 1996, was accused and convicted of murdering two of her children in Rowlett, Texas, and who currently sits on death row. If you are interested in hearing the entire true crime episode about her case, you can find that in episode number 33. I will have that for you in the show notes. And as soon as all of these trial readings are done, I'll be back to doing weekly true crime and paranormal cases. So let's get on with the next trial reading. Now, we last heard from Alan Brantley, and that was Alan Brantley number 3. He's an FBI agent who is on the stand currently for the prosecution. And let's go over a little bit as to what we heard in the last episode. At the very beginning, way when this started, when the defense began to question Mr. Brantley, Mr. Mulder of the defense made it clear that he was not going to treat this FBI agent, Mr. Brantley, any differently. He did show he was a little bit more assertive than with other witnesses. And what Mulder did was he challenged Brantley, essentially, about these different crime locations, because Brantley thought that, hey, the reason that he felt that the crime scene was staged was because one of the reasons, at least, was that there wasn't an easy in and out to their location. They weren't like directly off of an interstate or whatever. But, Mulder pointed out that their neighborhood is actually accessible to an interstate and a highway within less than 3 minutes. They also discussed or talked about a coworker of Darlie's. The thing is that this agent had access to records and photographs from the prosecution that the defense had not had an opportunity to see. Some of this stuff was new to them. But more importantly is this agent went ahead and he read through all of this information and did not actually talk with any of these witnesses. He just went through and read the information that was written down or that was in notes by other investigators and the Rowlett Police Department. And one of these that he read through that he was considering in regarding to his determining of whether or not this was a staged scene was that when he read over some of Barbara Jovel's testimony, and it came up in the last episode that Mulder mentioned if Brantley or asked Brantley if he happened to know that Barbara had actually been diagnosed with a mental condition and she had been institutionalized. And he said that no, he did not realize that. And as soon as this is said, it is objected to. And the reason for that was because way back when Barbara did testify for the prosecution, this information was also brought up then and was not allowed within the trial. So again, even though this particular point was brought up in front of the jury, they were asked to leave the room. There was a big discussion about whether or not they could talk about this. And of course, the judge said, no, you can't talk about this. And the jury was brought back in. And then they continued with the trial. A couple of other things was that Mulder, again, the defense attorney, argued that usually if somebody were to keep an eye on the house and they were familiar with the Routier home, they would know that it was usually Darren's car in the driveway and that Darlie's car was in the garage. And the fact is that at the night of this crime, Darren's car wasn't even there and Darlie's car happened to be in the street, which would suggest that maybe Darlie was the only one home. And another thing that was talked about was a neighbor who happened to hear a scream around the time of the crime. She had assumed that it was from a slumber party that was happening nearby, didn't think much of it, went back to bed, and then next heard the police and the ambulances and found out that something had happened. However, when she heard the scream, She looked outside her window and saw this black car with tinted windows out in the street, and it was not a familiar vehicle. Now, Agent Brantley did not remember reading this information. He was asked, hey, if you did read this information, would it have made any difference in his decision about the staged crime scene or how things happened? And he said they probably wouldn't have put a lot into that, but that's kind of where we left off. It is a very, very interesting episode. So if you do have the time, if you have not yet listened to it, I highly suggest that you do. It's incredibly interesting. Again, that is Alan Brantley, number 3, and I will have the link for you in the show notes below. But now we get on with his testimony. And at this point, they've moved to now talking about the garage and the crime scene. And that is where we begin. And we start again with the questioning by Mr. Douglas Mulder, who says, let me show you what has been marked for identification and record purposes as Defendant's Exhibit 62 and 63. And he asks the witness, Mr. Brantley, you can see it looks like a Dallas Cowboy trash can kicked over there, doesn't it? And he says, certainly. And here it looks like another trash can kicked over, doesn't it? Yes, sir, a wastebasket. So would that be some evidence of somebody going through? It could be, and I certainly considered that. And again, what I think that really addresses is you have those things laid down in a fairly conspicuous way. Certainly, there is nothing, again, damaged. I mean, these are plastic, kind of a tin metal wastebasket. No damage, no dent in that wastebasket whatsoever. Again, the question arose, is this something that was knocked over and disturbed as someone was going through there or as someone is trying to exit? And if someone is trying to exit and they got in so well, how come on the exit they knocked into these items? I think what we also considered was whether somebody may have pulled those things behind them to impede someone chasing them or delay someone from actually catching up with them. So we looked at those as well. You say that we looked at that. That is the guys at the behavioral science unit? Myself and other unit members, that's correct. What did you make of the fact that her underwear was never found? I'm sorry? I said, what did you make, you and the guys back at the unit, what did you make of the fact that her underwear was never found? I had no idea that her underwear had been taken. I don't guess that makes any difference, though, does it? It would if there had been something taken from the scene that I wasn't aware of. I would want to know that. But again, as far as I know, there had been nothing taken from the scene. All right. You, I guess, have some acquaintanceship with blood spatter evidence, don't you? Yes, sir, I do. That is fair to say. And a blood pattern interpretation? Well, I am not an expert in that area, but certainly I have had that kind of information presented to me before. Okay. Now, we're in agreement now that whoever did this thing finished off the boys before Darlie was attacked and her throat cut. Stabbed here a couple of times and stabbed in the chest. Are we in agreement? I believe that was my opinion. Yes, sir. It looks like they were assaulted first. Yes, sir. And by the way, did you know that her arms had been beaten? Well, I knew that there was some bruising to her arms. Okay, what did you make of that? Well, they are very interesting. I looked at that when I received the case materials and I asked quite a few questions. Okay. I wanted to know whether that was artifact or that was something sustained as a result of the medical procedures or whether that was something else. Okay. And I assume you are getting ready to tell us that that was artifact or that was part of the staging. Well, I'll tell you, it's a good question because initially I was informed that that may have been the result of the medical procedures that were performed at the hospital. And then later on, I understand that that was not the opinion of the medical doctor. When I first looked at them, again, because of the nature and the symmetry, they they certainly didn't look like anything that was coincidental to a struggle or being grabbed. It looked like something had either they had been beaten on something or something had been beaten onto her. a pretty determined individual if they are beating their arms up in the fashion that they are bruised all the way from the wrist to the virtually the shoulder, wouldn't you say? I recall what was distinctive. It was a very clear line of demarcation where from that line below, there was absolute no bruising. And then from that line above, there was significant bruising. The doctor says blunt trauma. What does that mean to you? Blunt force? Again, something striking the arm or the arm striking something hard. Okay. And I take it you factored that in? I certainly looked at that. Yes, sir. Okay. And you talked to Mr. Bevel, didn't you? I did. Okay. And he, no doubt, told you about the blood that was on her t shirt? He did talk about that. That's correct. Okay. And you found that interesting, did you? Certainly. I took that into consideration. Okay. And what consideration did you give that? Well, that was not a major feature. And again, as I testified on direct, that was really not anything that I focused on. That didn't mean a whole heck of a lot to you? Well, based on what I was trying to do and the focus of what I was doing, again, it was certainly not a major feature. Mr. Mulder then says, Judge, if you will bear with me, I want to get down, like on my knees here. And then Mr. Mulder again asked the witness, Mr. Brantley, this question. But Mr. Bevel had the opinion that Darlie got the blood on her by stabbing the boys and working the knife in this fashion. And the knife came up and spattered or cast off on her shoulder. Did he tell you that? He did not tell me that. No. Okay. And he said that in these areas where you see the multicolored kind of lifesaver looking deals, you see four of them on there. You will have to show me what you're referring to. The two here, the yellow and orange, and a couple here. Yes, sir. Okay. He said that those were occasioned when the knife was stabbed into the boys and came out and the blood spattered or was cast off on her shoulder. Does that make sense to you? Again, if that is Mr. Bevel's testimony, I can't really speak to that. Okay, well, as an analyst, I guess my question for you is, and he said that the blood here, and there is going to be testimony, he said initially it was a mixture. And then he said, well, Mr. Shook says, well, Judge, I'll object to him going into, Mr. Mulder then says, well, I'm going to, the court says, sustain the objection. Mr. Mosty says, excuse me, Your Honor, Mr. Bevel testified to that yesterday. Mr. Shook says, well, Mr. Bevel testified to a whole lot of stuff yesterday. And the court says, we understand that. Let's don't compare testimony. Let's move on. Mr. Shook says, we'll object to him going into any comparison. The court says sustained. Mr. Mulder says, all right. Let me ask you this, Mr. Analyst. If, in fact, these represent, the court then says, his name is Brantley, and please address him as such. Mr. Mulder says, Mr. Brantley, Agent Brantley. The court says, thank you. Mr. Mulder says, yes, sir. And then he continues, Mr. Brantley, if, in fact, these are mixtures of Darlie's blood and Devon's blood here, and Darlie's blood and Darren's blood here, the blood's mixed together and the knife is wet with their blood, right? I'm not sure if that is a question or are you telling me that? It's a mixture. Also, the court reporter is blocking my view. I can't see what you are referring to. Okay. Now, my question for you, I guess, is how do you factor that in to get this blood, her blood and the boy's blood, her blood and Devon's blood up there on her shoulder? The blood is mixed. That means the knife has to be wet with her blood and Devon's blood. Mr. Shook says, Judge, he's going into a conclusion. And there were two different areas of testimony given on that and the conclusion that he has given. Two different explanations. The court says sustained. Let's move on. Mr. Mulder says, well, Judge, are you telling me that I can't ask this analyst this question? These are facts based on evidence. The court says, well, if you will just make a succinct question, and if he knows the answer, he can answer it, please. Mr. Mulder says, all right. and then continues. Well, the knife has to be wet with both of their blood to be able to be able to stab and get that blood on her, if that is how it got on there. It has to have both her blood and the youngster, Devin's blood, on it at that time. And for that to happen, he must have already, she has either got to cut her throat first and injure herself first and then stab the boys and do it. Or she has got to stab the boys and then cut her throat and then go back and stab the boys again to do this. Mr. Shook says, Judge, I'll object again as to the misleading nature of the question because that is only one version of how those stains get there. And he is misleading the witness with that question. Mr. Mulder says, no, it's two versions. Take your pick. The court says, just a minute, gentlemen, please. If you know the answer, answer it. If you don't know it, please state so. The witness then says, Your Honor, I'm not sure I know what the question is now. The court says, well, thank you. That is probably a good answer. Mr. Mulder says, just a thing or two. Were you aware, Agent Brantley, that there were some suspicious people looking into the Routier garage the late evening of June the 5th? Were you aware of that? I am not aware of that. No, sir. Okay. That doesn't make any difference, does it? That would make a difference if I had that information, but I received no information that that had taken place. What if they were in a black car? Would that make it any more interesting for you? Would I take that into consideration? Yes. Is that your question? Certainly. Well, what? Are you going to give that any value of any sort? Well, any events leading up to these homicides, certainly I would. Again, anything especially in close proximity to that residence. Okay. What does that do for you? What does that tell you? Well, I would consider whether maybe that is part of some surveillance that may have been going on. Okay. Let me ask you this. How long would it take, in your judgment, to do all of this? To kill both boys, self-inflict the wounds, stage the scene, plant the sock, call 911. How long would all of this take? You are saying, I'm saying, how long would it take? If the defendant did this, how long would it take if self-inflicted? Yeah, because I haven't said that. I know you haven't. But again, I really have not assessed it. The only thing I base my opinion on is when the call came in and when the police responded to it. I certainly looked at the time of death from the medical examiner's reports. So again, I really have made no assessment as from the beginning of the event to the end of the event. Well, I'm asking you to do that now. I don't know that I can do that, sir. All right. I mean, now, what if you had the boys back at the behavioral science unit? Do y'all sit down and kind of brainstorm something like that and come up with a factor? I think depending on the condition of the victims and lividity and rigor and some other post-mortem changes in the body, I mean, you can tell. I think we would probably be able to assess whether the kids had been killed and were discovered fairly soon after the homicides or whether they had been there a while before they were discovered. But again, as far as giving you an exact time and again, a specific chronology, that is something that we don't do. Well, you see, all that information is available to you. Mr. Shook then says, Judge, I'll object. He just answered the question. The court says, overruled. I'll let him answer the question. Wow, that's a surprise. Mr. Mulder says, the majority of it has all been testified to here. I mean, we all know. Well, but again, I haven't been here for the testimony. Well, I know it, but I'm asking you, just based on everything that you have received, tell us how long it would take from start to finish or from start to the 911 call. Well, I would look at a variety of options. I know you would. If they were killed and then the perpetrator remained at the scene for some time before any of the other events occurred, like, as you said, the self-inflicted wound, they could have been killed or assaulted, and it could have been some time before the other injuries were inflicted. If it occurred coincidental to the children being assaulted, then it would be a relatively short period of time. How many minutes Just give me your best guess. I'm not going to hold you to it. Again, I'm sure you probably will, but again, I really am not comfortable with making that kind of assessment of chronology or time. Well, I noticed that when you were talking about the broken glass, you told the jury that you said, quote, hit the wine rack. Now, where on earth did you get the idea that somebody hit the wine rack? Well, I look at the condition of the wine rack and the glass breaking and the statements of hearing the glass breaking. Again, somehow that glass became dislodged. And because it was described as being coincidental to the offender escaping, unless the offender went by and knocked it off or hit into that wine rack, there is really no other way that that could have occurred. Well, now, wait a minute. There are a bunch of different ways that could have occurred, aren't there? Well, okay. Remember, I wrote it down, and you said that you were alarmed or curious that some of the other things on the wine rack were not knocked off. Yes, sir, that's correct. You said that when he hit the wine rack. Well, I mean, why does somebody have to hit the wine rack to break a glass? Well, there would have had to have been some sort of contact with the wine rack for that, I believe, for that glass to become dislodged and for the other items on that wine rack to be moved. Uh huh. So, are you suggesting that somebody took the wine glass and threw it down on the floor? No, I'm not. I didn't say that. And we can agree that you don't have to hit the wine rack to knock a glass off, do you? In fact, you could come by and just hit it with your arm or shoulder. Certainly. You could come by and pick it up off and throw it down. That is a way for it to come off. But if it were thrown down on the floor, you wouldn't expect to find shards up here on the shelf, would you? If it were picked up and thrown on the floor, clearing that wine rack completely, that is reasonable to assume. But of course, if you walked by and just knocked it up and it fell off and hit before it hit the floor, then then you would expect to find some shards here. That is reasonable. And maybe even in the little ice bucket top as well, if it were broken up here as opposed to being thrown down on the floor. Fair enough. That is fair to say. She didn't say in her statement that somebody hit the wine rack, did she? Well, my recollection is she heard the sound of breaking glass, not the sound of somebody hitting the wine rack. No, sir. Mr. Mulder then says, I think that's all. Thank you, Agent Brantley. Mr. Shook says, nothing further, Judge. And the court says, you may step down, sir. Thank you for coming. Mr. Mosty says, Your Honor, could we take care of a housekeeping matter? And the court says, we sure can. Just a moment. All right, ladies and gentlemen of the jury, we'll take a 10-minute recess now, please. And so the jury leaves the room and everybody else remains. And the court says, all right, let the record reflect that these proceedings are being held outside the presence of the jury. All parties in the trial are present. Mr. Mosty. Mr. Mosty then says, the district attorney's office is in the process of copying all of Mr. Brantley's file, except for the photographs, which we will mark and introduce for record purposes as Exhibit 70. And the court says, any objection to Defendant's Exhibit 70 for record purposes? Mr. Shook says, no, sir. The court says Defendant's Exhibit 70 will be admitted for record purposes after it is prepared. Mr. Mosty then continues, in that regard, Your Honor, what we would have covered in particular with Mr. Brantley as part of an offer of proof or a bill of exception is that we would have gone through and listed in particular all of those things that he had in his file, the Dallas Morning News reports, Altoona, Pennsylvania news reports, numerous summaries that I believe. The court says, just a moment, we have to have that noise stop. All right, now go ahead. Mr. Mosty then continues. Also, numerous summaries, and the court says, the noise has stopped now. If you would start again, Mr. Mosty, please. Mr. Mosty then says, this is simply with respect. Mr. Hagler will handle another matter in a second, but this is strictly in respect to the FBI agent. And the proof we would offer, and, of course, a lot of it will speak for itself in the record, but that he had in his file. And amongst the things that he had relied upon were news reports from Dallas, from Altoona, Pennsylvania. He had numerous summaries of witnesses who, I believe, were probably conducted by Bocello as summaries of testimony, many of whom have not testified, some of whom regarding the nurses, in my judgment, also provided exculpatory material that had never been provided to us in terms of witnesses that the state had interviewed, mainly in September, if I recall, but the dates will speak for themselves. And there were a number of other records that have not been introduced into the records. And again, those will speak for themselves. But we would have pointed out all of those things. And also, as a second part of this, the court denied us the opportunity to, on our behalf, to present information to the FBI agent for him to consider, thereby making all of his testimony a one-sided version of what the state had given him, which denies us, of course, our right to confront and cross-examine the witness. And, as a third part, of course, the court has denied us the opportunity to put those psychiatric records of the witness Jovel into evidence. And all of those would be part of going back to and incorporating our original Daubert objection as to this witness testifying, and would remind the court on the many occasions where the witness, for instance, turned to the jury and said things like, quote, "Why wasn't there enough force?" or, quote, "I believe that this is a contradiction." Those are the things that are specifically prohibited by Daubert. And all of this testimony amounted to was putting someone under oath and delivering the state's final argument. And for all of those reasons, we reincorporate our Daubert objection and we request the court to instruct the jury to disregard all of his testimony. The court says, "Thank you." Mr. Mosty says, "Is that request denied?" The court says, "That request will be denied." Mr. Mosty says, "And we would move for mistrial." The court says, "Motion for mistrial denied." And of course, the court will also note that as regards to Mr. Brantley, all questions asked to Mr. Brantley were referred to exhibits already in evidence or placed in evidence during his testimony. Mr. Mosty says, "I'm sorry, I didn't understand that." The court says all questions asked to Mr. Brantley when we were referring to various exhibits and things referred were he was questioned on exhibits already in evidence, or from exhibits already in evidence, or exhibits placed in evidence during his testimony. Mr. Mosty says, and of course, the court will also note on the record that he said that he relied on a number of documents that are not in the record. The court says his testimony will be noted, and all of his testimony will be in the record. All right? Now, we have covered Mr. Mosty, Mr. Hagler. Mr. Hagler, then again of the defense team, says, "Thank you, Your Honor. I have just one brief objection." The court says, "Oh, okay, go ahead." Mr. Hagler says, "Your Honor, again, we have already objected and, of course, certainly understand the court's ruling. However, after hearing this witness's testimony, it's pretty apparent that there is only one conclusion that can be drawn from his testimony, and that is the conclusion, at least from his standpoint, that the defendant committed the offense. Now, regardless of what his testimony was, where he said he never testified that the defendant did it, and although admittedly maybe he never did make that specific statement, it is pretty apparent that the sum total of all of his testimony is that the defendant did commit the offense. And again, the sum total of his testimony constitutes a violation of 704. I should say it goes beyond the scope of 704 in the fact that such testimony reaches the issue of ultimate guilt or innocence of the defendant. And therefore, we would move for a mistrial based on the admission into evidence of that testimony based on the 5th, 6th, and 14th amendments. The court says, "All right, motion for mistrial denied." Anything else? Are we ready to bring the jury in? Mr. Davis says, "Yes, sir." The court says, "Just a moment." Mr. Mulder says, "Judge?" The court says, "Yes, sir." Mr. Mulder says, "I assume they're going to rest just as soon as the jury comes in, and we're going to make a motion for a directed verdict, which, in line with everything else you have done, I'm sure you will deny it." The court says, well, we will certainly hear the motion, Mr. Mulder. Mr. Mulder says, well, are we going to run the jury out twice or can we do it now? The court says, yes, we can do it right now. Is that satisfactory? Mr. Davis says, yes, sir, that is fine. The court says, all right, go ahead with your motion, Mr. Mulder. Mr. Mulder says, well, we are going to wait until they rest. Mr. Greg Davis says, while we're here outside the presence of the jury, the state will announce at this time that it rests its case in chief. The court says, all right, you will do that again in front of the jury. Mr. Davis says, yes, sir, I will. The court says, and you are ready to go forward? Mr. Mulder says, yes, sir. Court says, you can have your motion now. Mr. Hagler then says, okay, Your Honor, with leave of the court, before they rest in front of the jury, Your Honor, we would urge that a review of the evidence by this court, which is obviously it has the power to do in determining whether or not the state has satisfied their burden of proof. And we would urge, Your Honor, that in reviewing all of the evidence, the testimony and exhibits and documentation, that the state has failed to carry its burden of proof under Jackson versus Virginia. In fact, in light of the fact that a rational trier of the fact could not have found that the defendant committed all of the elements or any of the elements alleged in the indictment, and based on the state's failure to carry the burden under Jackson versus Virginia, we would urge this court to instruct a verdict of not guilty. The court says, all right, motion for instructed verdict of not guilty is denied. And if you will bring the jury in, please. The court then says, all right, be seated, please. Let the record reflect that all parties in the trial are present and the jury is seated. Mr. Davis. Mr. Greg Davis then says, yes, sir. May it please the court, Your Honor, and ladies and gentlemen of the jury, at this time, the state of Texas rests its case in chief. The court says, all right, ladies and gentlemen, that's all the testimony you are going to be hearing from the state. That is their case in chief. And we will end this right here because the state has rested and it is now time for the defense to start their series of questioning. And we will pick up with the defense in the next episode. All right, so let's recap what happened in this episode. So it essentially began with some talk about the trash cans that were knocked over near the window in the garage of the Routier home. There really wasn't any kind of definitive answer about these cans. One of the thoughts was that they were knocked over as someone entered. But Brantley mentioned that the tin can, there were two cans in there. One was plastic, one was tin. The tin can was not dented. Now, I can tell you, and my husband would back this up, I can tell you from personal experience that I, in my lifetime, have accidentally run into a trash can or two like these and never in my life have dented them. Then there was another thought about these cans that they were put there by someone as they were exiting, trying to impede someone chasing them. And Brantley considers their placement conspicuous, is what he said, conspicuous. If they were placed there by someone or even touched by someone, why were there no fingerprints taken off of these items? And at least I haven't heard yet in this trial if they were or not. Were they even collected for evidence at all? I don't know this. Maybe we'll find this out. Mulder then goes right into the question about the missing underwear, Darlie's missing underwear. And Agent Brantley was not aware that anything was missing or had been removed from the crime scene. Now, this is actually not true because he knows for a fact that the sock found down the alley was something that was removed from the crime scene. Brantley, again, believes that it was the boys who were harmed first before Darlie. He also doesn't really give an opinion on the bruising on Darlie's arms, but does mention that there seems to be a line of demarcation, which suggests that her arms were hit with a blunt object or the arms were struck on a blunt object, implying that she did this to herself. When it comes to discussing what Mr. Bevel, the blood spatter expert, had testified to in regards to the blood spatter on the back of Darlie's shirt, it gets objected to by Mr. Shook. Actually, Mr. Shook starts to state his objection. And then Mr. Mosty interrupts him by starting to say, he's trying to explain himself. And then he gets cut off by the judge, who says he'll sustain the objection. But the objection wasn't even completed. How does he even know what Mr. Shook was objecting to? The line of questioning about this blood spatter on this shirt, this continues for some time, but ultimately it doesn't lead anywhere because the prosecution keeps objecting and the judge keeps sustaining it. Mulder then moves on to asking about the black car and if Brantley knew that there was a black car that had been seen outside the residence the day before the crime. He said he didn't remember reading anything about that, but said it may have made a difference in his judgment. Since this was testified to earlier by another witness about this black car near the Routier home, surely this had to be in the documentation, right? Maybe not the testimony, but I believe it was both Barbara and her mom who did the housekeeping for Darlie for a few days, that were ultimately persuaded by Darlie's sister to go to the police and report that they saw this car outside of the Routier garage, which they did. Was he not given these police reports to review? Or was he given them and just didn't read them? The questioning then moves on to how long Agent Brantley would think all of this, the crime, the sock placement, the 911 call, how long would all of this take to get done? He does talk about how what he looked at was when the 911 call came in and how soon the police responded. He evidently looked at the time of death from the medical examiner's reports. And according to him, depending upon the condition of the bodies, the lividity, and the rigor, that this would be something that could help in determining the chain of events. But then again, Mr. Shook objects. It's actually overruled, believe it or not, and he's allowed to answer. But we still don't get an answer. We just hear how he doesn't feel comfortable giving a set time or chronology of events. They then move on to talking about the wine rack and whether or not somebody actually hit it. He does specifically say that he didn't mention someone had taken that wine glass and threw it on the ground. And Mulder actually gets him to agree that someone could have come by and just hit it with their arm or their shoulder. And after this talk of the wine rack, Mr. Mosty then concludes his questioning. And after the jury leaves for their 10-minute break, there is a discussion between the attorneys and the judge. The defense lets everyone know that they are copying all of the records that the witness, Mr. Brantley, had, all except for the photos. But quite a few things happen outside of the jury. Mosty talks about, again, of the defense team, Mosty talks about the information that Brantley had access to, which was not introduced into evidence. And the defense was then denied the chance to show Brantley certain information. And they feel that this makes his testimony one-sided. And they want to have the judge tell the jury to disregard his testimony. The court denies this request. Next, Mr. Hagler, also of the defense team, he objects to Brantley's testimony, talking about Rule 704. Now, evidently, Rule 704 means that a witness cannot give opinions on the guilt or innocence of a defendant. And he talks about, again, the Daubert standard. We've talked about this before, which essentially means that expert testimony should be based on scientifically valid reasoning that can be properly tested. Hagler also brings up the 5th, 6th, and 14th Amendments. And what these are is the 5th is protecting against self-incrimination. The 6th is ensuring the right to a fair trial. And the 14th Amendment is a guaranteed equal protection under the law. He argues that all of Brantley's testimony violates these rights. So what he does is he moves for a mistrial, which is denied. After it was discovered that the state was resting their case, Mr. Mulder then motioned for a directed verdict of not guilty, saying that the state hasn't met its burden of proof under Jackson versus Virginia the Jackson versus Virginia standard, which means that the evidence must be strong enough that any reasonable and impartial jury or judge could find the defendant guilty beyond a reasonable doubt. It's meant to be sure that convictions are based on solid and convincing evidence. The court denies this motion. So the jury is brought back in, the state has rested, and now we move on to the defense and their witnesses, which will begin in the next episode. Thank you all so much for listening. You are all so truly, truly appreciated. If you liked today's episode or you liked any of these episodes, please give it a thumbs up and leave a comment on the YouTube podcast page or subscribe and like wherever you listen to your podcasts. I really do love reading your insights and your feedback, especially on YouTube. It's where I'm at most of the time. And if you're not sure how to get there, you can find a link in the show notes below. And I will be back with the beginning of the defense side of the trial. Until then, bye for now.